Good morning and welcome. My name is Dean Reuter. I'm Vice President and Director of Practice Groups at the Federalist Society. Thank you all for being here this morning. I usually like to, as I kick off the second and third days of the convention, say that you've managed to make it to the best day of the convention. So I'll say that again today, but it's going to be tough to top the events of last night and the interview by Judge Sykes of Clarence Thomas. So thank you all for being here this morning. Again, if you couldn't hear me, my name is Dean Reuter. I'm Vice President and Director of the Practice Groups at the Federalist Society. Some of you might have noticed that some of our breakout sessions are being opened or introduced by the chairman of our various practice groups. So I want to make a brief commercial announcement. Some people don't know too much about the practice groups. And as director of the practice groups, I'll tell you that they are the most important part of the Federalist Society. There are 15 practice groups covering every legal area of law you can think of. We cover the entire waterfront, including maritime law, with our practice groups. And they do a lot of the planning for this event. They do a lot of the planning and execution for programming we do here in Washington and across the country on a variety of topics. They do a lot of the scholarship of the Federalist Society. And hopefully a lot of you have heard about the Teleform conference calls that we've been doing now for the past couple years. We do those as well. Each one of our 15 practice groups is run by an executive committee of volunteers. It is those volunteers who help make all of this happen. We have many, many more volunteers than we have staff, and we really try and get those volunteers to do the heavy lifting, and they're very good at it. The commercial announcement here is that we're always interested in adding to the ranks of our very active membership. I've seen a lot of you here year after year, and we certainly appreciate you showing up to our events. But I would encourage you to contact me, or contact one of my staff members. They're the folks with the red ribbons, or contact one of the practice group chairmen, and you can do that this weekend, or you can do that at your leisure by email or telephone later on. But there is, as you can imagine, as you well know, there's a lot more to be done. And we're in need of more assistance, more volunteer help. So I'd encourage as many of you as possible to get more active in the Federalist Society's practice groups. With that, I'm going to very briefly introduce our next panel, our moderator, longtime friend of the Federalist Society, recidivist moderator, Fifth Circuit Judge Edith Jones. Please join me in giving her a warm welcome.
Thank you, Dean. In federal sentencing law, recidivists are called career criminals. I'm pleased to be here this morning. Grateful to have the opportunity to moderate such an extraordinary panel as we have here of professors, many of whom have not only law degrees but philosophy advanced degrees on the subject of textualism and constitutional interpretation. First of all, I would ask you, please turn off your cell phones or any other noisy devices you may have. The panel, in order, I will introduce them briefly in order of their speaking to us. Each member will speak up to about 15 minutes, then we'll have a round of discussion among the panel, and then have plenty of opportunity left over for questions, I believe. The first speaker is Randy Barnett, also no stranger to the Federalist Society, the Carmack Waterhouse Professor of Legal Theory at Georgetown University Law Center, where he teaches constitutional law and contracts. He was a graduate of Northwestern University and Harvard Law School, and was a felony trial prosecutor in Cook County, probably a very busy place to do that. In 2004, he argued the Gonzalez versus Raich. In 2012, he was involved in the NFIB v. Sibelius litigation. Publications include 11 books, more than 100 articles, new editions of 2 of his books, Restoring the Lost Constitution and the Structure of Liberty, are about to come out this year, as well as a co-authored book, A Conspiracy Against Obamacare, The Volokh Conspiracy and the Healthcare Case. Next is Richard Primus, professor at the University of Michigan Law School since 2001. His father was a professor of theology at Notre Dame, and he has deep Notre Dame roots. He has also served as a consultant to state governments and private businesses on issues of state and federal constitutional law. His degrees are from Harvard, JD from Yale, a JD in philosophy from Oxford, where he was a Rhodes Scholar. He clerked for Justice Ginsburg and shared with Randy Barnett the first ever Guggenheim Fellowship in Constitutional Studies. Professor John McGinnis is the George C. Dix Professor of Con Law at Northwestern University. George Dix was my criminal law professor at UT at one time. He's a graduate of Harvard and Harvard Law School, where he's the editor of the Harvard Law Review with an MA degree from Balliol College, Oxford. He was the Deputy Assistant AG in the Office of Legal Counsel from 1987 to 91. He's the author of a couple of books, but most recently of a book that he will be describing in his remarks today. And finally, Professor Mitchell Berman holds the Richard Dale Endowed Chair of Law and Professor of Philosophy at the University of Texas at Austin. He teaches and writes in a variety of fields, specializing in American constitutional theory. He's a co-director of the law school's Law and Philosophy program. He has a degree from Harvard, JD, and MA in political science from the University of Michigan. Before joining the faculty of the UT, he was he clerked for Judge Phillips on the Fourth Circuit, and he practiced law. And a source has told me that he is a very fine fellow to work for, and if our discussion of constitutional interpretation flags, we will also go into his avocation, which is the jurisprudence of sport. One used to think that this was an easy subject, constitutional interpretation, and to tell you how far we've come, let's compare what our scholars today are going to say with what Joseph Story wrote about the Constitution. In construing the Constitution of the United States, we are in the first instance to consider what are its nature and objects, the scope and design as apparent from the structure of the instrument viewed as a whole and also viewed in its component parts. Where its words are plain, clear, and determinate, they require no interpretation. Where the words admit of two senses, each of which is conformable to general usage, that sense is to be adopted, which, without departing from the literal import of the words, best harmonizes with the nature and objects, the scope and design of the instrument. On the bench, we all aspire to that clarity and simplicity of thought. 200 years of experience has taught us that that's not always possible. We'll begin with Professor Barnett.
Well, thank you, Judge Jones, for the introduction. Thank you to my co-panelists for agreeing to participate. Thank you to all of you for coming. I see a lot of familiar faces out there. I see current students, I see former students, and lots of friends and colleagues. It's great to see you all. Well, originalism has come a long way over the past 20 years and is now considered the theory to beat amongst constitutional law professors. Now, in part, this is because originalist scholars took seriously the powerful critiques that had been launched against originalism in the 1980s by such folks as Paul Brest and Jeff Powell, and responded to these criticisms by refining their position. The first and most important refinement was championed early on by Justice Scalia, even before he was on the court. This was the shift in focus from the original intentions of the framers to the original public meaning of the text, a move that obviated most of the practical objections that had been made against the feasibility of originalism. Looking for the communicative content of the words on the page taken in context at the time of enactment is not that different from interpreting the public meaning of a writing today. The meaning of language has not shifted all that much since the founding, and any linguistic drift that may occur can generally be identified by reading evidence of contemporary usage. So while the word commerce today can sometimes loosely be used to describe economic activity, although not non-economic activity, even today, commerce more literally refers to the movement or trade of things from one place to another. as the overwhelming body of evidence from the founding period shows, it meant then as well. So too does the word arms mean weapons today, just as it did in 1791. The second significant refinement to originalism was a frank recognition of its limits. Whereas some in the past might have assumed that appeals to the intentions of the framers, or more accurately, how the framers would have decided a particular case, could produce results in most, if not all, cases and controversies, originalists came to understand originalism as a method of interpretation. Strictly speaking, interpretation is the activity of discovering the communicative content of the words of the Constitution. In short, interpretation is the activity of discovering the information that is contained in this short little book. But that information may or may not be sufficient to resolve a particular case or controversy. And we must figure out a way, and in addition, we must figure out a way to put the information that is there into legal effect. The activity of giving legal effect to the information that is contained in this book has come to be called constitutional construction. Indeed, the distinction between the activity of interpretation and the activity of construction, that is, the distinction between ascertaining the meaning of a written text and giving legal effect to that meaning, was traditionally recognized not only in constitutional law, but in the law governing contracts and wills. We can illustrate the difference between interpretation and construction by considering the case of D.C. versus Heller, in which the Supreme Court considered the constitutionality of a ban on all private possessions of handguns in the District of Columbia. To decide the case, the threshold question was whether the right of the people to keep and bear arms was an individual right akin to the right of the people peaceably to assemble and to petition the government for redress of grievances in the First Amendment, or the right of the people to be secure in their persons, houses, papers, and effects, to which the Fourth Amendment refers. Now, there were not an infinite number of potential answers to this question. Since at least the 1960s, gun control advocates and most law professors and all the lower federal courts of appeals had decided that the right of the people to keep and bear arms had denied that the right of the people to keep and bear arms referred to an individual right. Instead, they contended that it referred to what they called a collective right of states to maintain a militia, the importance of which was affirmed by the preface to the Second Amendment, which reads, "A well-regulated militia being necessary to the security of a free state." Because, however, the linguistic meaning of the right of the people to keep and bear arms in 1791 is an empirical rather than a normative question, whether it protected a collective rather than an individual right was susceptible of being resolved by examining evidence of linguistic usage. In the 1980s and 1990s, an extensive literature developed that so effectively refuted the reigning collective rights interpretation that it was abandoned by every scholar who participated in this debate, which some of you may not be aware of, but that's what happened. In its place, in the late 1990s and 2000s, some legal scholars and historians postulated that the Second Amendment protected not the right of a state, which is what we've been hearing for 20 years before, but now it was thought to protect an individual right to bear arms in an organized militia. So it was an individual right to bear arms, but in an organized militia. It was this formulation, not the repudiated collective rights interpretation, that Justice Stevens defended in his dissenting opinion in Heller. Now, this is not the place to rehearse all the problems with this newly minted alternative to the more straightforward individual rights interpretation. I limit myself to just one observation. Like those who previously defended the collective rights interpretation, proponents of the new militia-conditioned individual right were unable to produce a single example of anyone from the founding period who said that this was the meaning of the right to keep and bear arms. In short, they could not provide a single example of anyone who expressed the view that they claimed everyone held in 1791. And few, if any, even tried to contest the historical evidence that in 1868, the privileges or immunities of citizens of the United States that was protected from straight abridgment by the 14th Amendment included a personal right to arms. The evidence of that is simply overwhelming. The lesson of this highly contentious debate for the feasibility of originalism is clear. For all the Sturm und Drang of the academic debates over the meaning of the Second Amendment, in the end, there were only 3 contending theories of what the communicative content of the Second Amendment was in 1791. And the evidence overwhelmingly supported one of these 3. Justice Scalia's opinion in the Heller case was a model of how original public meaning interpretation should be done, as was Judge Silberman's lower court opinion in the D.C. Circuit and the late Judge Garwood's opinion in the Fifth Circuit in the Emerson case. Now, of course, if the right to keep and bear arms was either a collective or a militia-conditioned individual right, then Dick Heller was not protected by it. Only if it was an individual right of his could he challenge the constitutionality of the D.C. gun ban. But then, the court, assuming it is an individual right and he can challenge it, the court must then confront the question, did the district's total ban on the possession of handguns constitute an infringement of this individual right? Now, this required a bit more analysis that I'm not going to replicate here this morning. The answer of the court seems eminently reasonable. A complete ban on a type of weapon in common use for both individual and collective self-defense seems like an infringement of the right to bear arms. But what about bans on other weapons or other restrictions or regulations of this right? I now come to the most criticized portion of Justice Scalia's Heller opinion, in which he concludes without much analysis that, quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms, unquote. Critics have been harsh in their treatment of this dicta for seeming ad hoc and unsupported on originalist grounds, especially in contrast with the pages and pages of originalist analysis that preceded it. Now, there are 2 ways one might support the claim that these sorts of laws that Justice Scalia named do not infringe on the right to keep and bear arms. The first is a matter of interpretation. If evidence of the original content and contour of the right to arms is precise enough to show that the communicative content of the right of the people to keep and bear arms excluded these sorts of laws from being considered infringements, then that would settle the matter on originalist grounds. But the evidence of original meaning is not that fine-grained, as should be apparent from a 30-year debate over the more abstract issue of whether it referred to an individual or to a collective right to arms. Yet just because the original meaning of the right to keep and bear arms is not precise enough to rule in or out all or some of these types of restrictions on who can possess a gun and where, does not end the role of the judiciary to follow what the Constitution and the Second Amendment does say. It would be an abdication of the judge's judicial duty to follow the law that is provided by the written Constitution to shrug his or her shoulders and say, well, in the absence of this level of specificity, I suppose the textually acknowledged individual right to keep and bear arms can be regulated or restricted however a legislature might wish, so long as these regulations fall short of a complete ban on possessing any weapon. To see what more than this is required of a judge, consider the indisputably individual right to the freedoms of speech, press, and assembly. However textually clear these rights may be, it does not convey the sort of specific information needed to resolve, for example, what counts as a reasonable time, place, and manner regulation of speech and assembly, and what is unreasonable. Indeed, the list of questions that are not resolved by the text of the First Amendment can seem overwhelming to anyone who has studied this area of constitutional law. And yet everyone, but I think Lino Graglia, would acknowledge that some judicial assessment of restrictions of speech must be conducted, lest the legislature restrict the rights of freedom of speech, press, and assembly at its discretion. How then to conceive of the judicial duty to give legal effect to the communicative content of the First and Second Amendments when that communicative content is not specific enough to resolve a particular case or controversy? Like many other originalists, I conceive of this separate activity of developing legal doctrine, such as the doctrines of time, place, and manner in speech, or the doctrine of content neutral or viewpoint neutral regulations of speech, as the activity of constitutional construction. Constitutional construction. as opposed to interpretation. But not all originalists are comfortable with this distinction. Some think authorizing judges to engage in something called construction, when the meaning of the Constitution is inadequate on its own to resolve a case or controversy, places far too much discretion in the hands of the judiciary. For example, in his new book with Brian Garner, Justice Scalia criticizes the distinction between interpretation and construction. Like some other originalist friends of mine, they seem to have been spooked by Jack Balkin's capacious use of constitutional construction in his book, Living Originalism. If that is what a recognition of constitutional construction leads to, they seem to think, then there must be something wrong with this basic idea. But I think this rejection is wrong for two basic reasons. First, wishing does not make it so. Regardless of what you call it, the creation of a more specific legal doctrine to implement what the Constitution says is not only what courts have always done, it is simply unavoidable. Even a rule that says, quote, when the original meaning of the Constitution is not specific enough to resolve a particular case of controversy, then judges should defer to the legislature and uphold the law every time, is itself a rule of construction. So even when those who seem to oppose judges engaging in construction must themselves engage in construction to reach that conclusion, and must then urge judges to adopt their rule of construction, the rule of judicial restraint. But now perhaps their preferred rule of construction is right, but it still must be normatively defended as such, since no such rule is communicated by the text of the Constitution itself. Given the reality that there are two different activities here being performed, Justice Scalia's seemingly ad hoc list of exceptions shows that a refusal to recognize the distinct activity of construction only confuses matters and undercuts the coherence of originalism itself. It appears he is making up limitations on the right because he feels they make sense, which is not what an originalist judge is supposed to be doing. Yet it is exactly what a judge is supposed to do when implementing the original meaning of what the Constitution does say. Now, another reason this concern over constitutional construction is unwarranted is because constitutional construction does not need to repose objectionable discretion in judges. For example, I just mentioned the judicial conservatives' construction that judges should uphold legislation whenever it is not clearly prohibited by the text of the Constitution. This is a construction that does not give discretion to judges, but it's still a construction. So construction does not equal discretion, is the point I'm trying to make. Now, to be clear, I myself reject this judicial restraint rule of construction for reasons I'll make clearer tomorrow when I'm on the program with Judge Wilkerson. But I reject it because it is not consistent, in my view, with the spirit of the Constitution that says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, and that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. These too are provisions of our written Constitution, and each has a definable original meaning. Although I address the original meaning of these passages at length in my book, Restoring the Lost Constitution, a newly updated and expanded edition of which will be available on sale after this session, out in the hallway, now is not the place to present the evidence that shows that both are referring to individual natural rights, though the original meaning of privileges or immunities is broader and includes some enumerated rights as well. But if that is what the weight of the evidence shows, then developing, implementing rules to give legal effect to these written amendments to the Constitution is a duty of the judges who wish to faithfully follow the text of the Constitution. Which brings me to my final point about construction. Rules of construction to implement these passages of the text need not authorize judges to identify or speculate about these rights. Instead, the retained liberties of the people can be effectuated by allowing citizens to challenge the rationality of legal restrictions on their otherwise rightful liberties, as they were allowed to do until 1955, when the Warren Court decided the case of Williamson v. Lee Optical. The techniques used by the lower court in Williamson in that very case to smoke out the pretextual nature of that Oklahoma law as a measure to protect ophthalmologists and optometrists from competition rather than as a genuine health and safety measure was well within the judicial competence of that bench. When protecting liberties that are enumerated in the Constitution, judges do this without breaking a sweat. Just read the lower court opinion for yourself to see how it can be done to protect an economic liberty to pursue a lawful occupation without opening the door to unfettered judicial discretion. Now, of course, the fact that judges are under a duty to assure that legislatures are acting within their proper power when they restrict liberty in no way authorizes judges themselves to govern the people or restrict their liberties. Judges simply have a duty to say no to the legislature, and judicial negation is not legislation. Let me now conclude this talk by turning my attention very briefly away from the feasibility of originalist interpretation and the constitutional construction that is needed to legally effectuate that meaning, to the normative question of why judges ought to adhere to the meaning of the text at the time it was enacted, whether that be 1789, 1791, or 1868. You will hear much more about this from John, who goes later on this morning's panel when he presents the normative theory that he and Mike Rappaport present in their new book, which will also be on sale in the lobby after this session. For me, the normative case for originalism can be boiled down to the following propositions. First, sovereignty resides in the people of the United States, not the government of the United States. Second, a written constitution is a means of protecting the rights retained by the sovereign people by providing the law that governs those who govern us. Third, those who are to be governed by this law can no more change it on their own than we can change the speeding laws that are imposed on us without going through the legislative process. So neither the president, nor Congress, nor the Supreme Court, nor all of them together can change the meaning of the law that governs them without going through the amendment process. In sum, originalism can be summed up in one simple phrase. The meaning of the written Constitution that governs those who govern us must remain the same until it's properly changed. I submit to you that it is the very simplicity and compelling nature of this proposition that more than anything else explains why originalism is today the theory to beat in constitutional law. Thanks.
Great. Good morning. Randy's terrific. And he is. He is. In fact, and he and I have, I think, considerably more in common than most people realize, despite the fact that I'm going to disagree with a fair amount of what he said. But I'm going to agree vigorously with the last thing he said. I think that a very large amount of the explanation for why originalism has the attractions that it does have to do with the simplicity and compelling nature of the story that is told in the last sentence Randy spoke. Simple stories are persuasive, and stories like this one that remind us of certain important values about democracy are attractive. Now, I also want to agree with another thing that Randy said, which is wishing doesn't make it so. Sometimes the simple story doesn't tell you everything that you would know on further reflection. Sometimes the simple story won't get you there. Sometimes to get the things you want, like democracy, you need something a little more complex. So I'm going to start by making things a little more complex. First, the title of this panel, I think, is Textualism and Constitutional Interpretation. But the subject discussed at this panel so far mostly, and will continue that way mostly, is not so much textualism as originalism. I emphasize so much. Randy talked about both. We'll talk about both. But I want to emphasize it's both. That is, textualism and originalism are not two names for the same thing, despite the fact that this panel's title and subject and other things at this conference similarly seem to treat them as if they were. And in order to get a firm view of what is both strong and weak about either textualism or originalism, it is necessary to get a clear view of what it is and what it isn't, rather than running the two of them together. So, and now, The conflation is a little bit understandable because there are a couple of things that they're supposed to do that are the same. Notably, and as Randy said, they both promise to render the law fixed, right? That is to say, to make the content of the Constitution independent of the changing preferences of the people who occupy judicial office. But they might be two different ways of doing that rather than just the same thing. The strict textualist needs only the text. The strict text, one can be a textualist about any document, not just a constitution, without knowing the history of the document. You could put the Constitution in the hands of a competent reader of English who knew nothing about the United States before the year 1900, and that person could engage with the text. The person wouldn't know many things that you know, right, that might go into constitutional interpretations, but those are things that in an important way are not just the text. Originalism needs things that aren't the text. Originalism is useful, if it is useful, precisely because not everything about constitutional meaning is in the text. Now, many people have thought that the biggest problem with originalism is its fundamental hostility to democracy. That is, a set of rules, hard to change, that none of us participated in forming, seems like an anti-democratic set of constraints. People have tried to solve this problem with, I think, limited success. But I think that this isn't the real problem. Nor, I think, is the real problem the one that runs, it seems like a strange way to try to run a country, to try to do it on the basis of rules from that long ago. Suppose I said, let's identify the 50 smartest and most honorable people at this conference and ask them to design a government that would function well in the United States in the 24th century. I think we'd scratch our heads a little bit and say, I'm not sure we know what we need to know to do that. But these are not, I think, the most pressing problems with originalism. The most pressing problem is a practical one, which is this: it will not deliver the stability and the constraint that is supposed to be its chief attraction. One of the reasons that I'm not an originalist about the Constitution, I'm an originalist about other sorts of texts. I'm an originalist about shopping lists, for example. If my wife sends me to the supermarket with a shopping list, and the shopping list says 2 eggs, and I return home with 2 eggs, my wife will say, "What have you done? You have not executed your office." And she'll be right, because 2 eggs on the shopping list means 2 dozen eggs. That's not in the text. It is the original meaning. It is what the founder wanted and what a reasonable person would have understood by it. And my job in that social role is to get the founder that. The Constitution is different. We are not the agents of the principle long dead. We are the people governing. Originalism invites, practically forces judges to enact their own worldviews in substantial part, rather than to hold the content of the law stable. It does so, I say again, not because the judges are acting in deliberately underhanded ways. This is what it does if the judges act in good faith. Because the Constitution is not like a shopping list. The shopping list addresses a pretty simple set of topics. It is written by someone whose full worldview I have pretty good access to, and written for a limited audience. And there's not so much at stake in disagreeing about it. The material that an originalist interpreter has to confront to produce an interpretation of an 18th century text is, first of all, vast. Many, many documents, speaking in many, many voices, saying many different things. Professional historians, after long struggle, disagree about many of the things here. My friend Gerard Magliocca has written perhaps the most important line in modern constitutional theory. It runs, "Constitutional lawyers are paid to masquerade as historians." And paid well. But it is a masquerade. And one of the reasons that we know it's a masquerade is that the real historians, the good ones anyway, embrace the ambiguity rather than trying to say, it means this. Now, what happens when you take intelligent people of good faith and say, from this morass of conflicting multivocal material, produce a rule? There is a very strong tendency for people to produce the rule that is the sensible one, right? Out of that vast ambiguity. Imagine this. You are a law student. You confront the final exam. The final exam says, please interpret the following provision of the Constitution based on its original meaning alone. This provision of the Constitution, its original meaning, have not been discussed in the course of the semester. You have had no previous acquaintance with this particular history. You do not know the professor's views about it. What are your chances of going into the law library and producing the interpretation that the professor has in mind? Contrast them with your chances of producing the interpretation the professor has in mind if the professor asked you to decide a case under the most recent set of case law. Also not 100%, but considerably more determinate. We know this from practice. Look at what happens. Does the pursuit of original meaning actually bring judges of different worldviews to the same conclusion? It doesn't look like it. Over and over again, the court splits in roughly the same ways, with judges interpreting original meanings to support roughly the same sets of solutions that we imagine those judges might have thought to be sensible in the absence of original meanings. The point I'm making is a practical one. If what you think original meanings gives you is a stable law independent of the worldviews of the judges, there's very little evidence that it delivers that. Randy tells a very good story about changing understandings of the Second Amendment. And a story about changing understandings is exactly what it is. We know, most of us, the story of the changing understanding of the original meaning of the Equal Protection Clause. When Brown versus Board of Education was decided, pretty much everyone in the professional class understood that the original meaning of the 14th Amendment did not require the desegregation of the schools. Brown was much criticized for this reason. But in the course of time, pretty much everyone came to think that Brown was rightly decided. And if it's rightly decided, so the theory goes, the original meanings must support it. I don't know if Steve Calabresi is in the room, but he, like Michael McConnell before him, performed important functions in this process by rereading original sources to conform with what everyone knows is the right answer. Now, you may think all to the good. We've come to the right original meaning of the Second Amendment, and we've come to the right original meaning of the Equal Protection Clause. But not everyone thinks it's right. How will you feel when people with a different set of intuitions from yours have a majority of those making the decision? How will you feel when society continues to change and the original meaning continues to change with it? My students across the political spectrum, almost uniformly, members of the Federalist Society and otherwise, believe that there is no good reason for the state to deny gay marriage. They also believe that the original meaning of the 14th Amendment requires the state to authorize gay marriage. None of my students thought that 12 years ago. They pretty much all think that now as a matter of original meanings. Again, this is all in good faith. It happens because we love the founders and we want them to share our values. We do. So, original meanings change as our values change. And when we disagree about our values, we disagree about original meanings. Now that's original meanings. What about text? The core idea, again, here is that text carries meaning independent of the judges or the other people interpreting that text. This is supposed to deliver not just stability, but also transparency. And it does to some extent, but it lies along a continuum. May I? Textuality is a continuum. Propositions of constitutional law are more and less textual rather than textual or not. So, for example, this is one end of the continuum, right? At one end of the continuum, the constitutional rule, I'm going to show you only constitutional rules that everyone agrees today are operative constitutional rules, even if not everyone agrees that they all ought to be. Here's one, right? At one end of the continuum, the rule is stated in the text. The rule is that every state gets 2 senators, and that's pretty squarely in the text of the 17th Amendment. Move off of it just a wee bit. Some rules are not squarely stated in the text, but pretty fairly implied by them. Congress can create an air force. The text says Congress has the power to raise and support armies. It's not a big inference to say, under modern conditions, that includes an air force. Now things get a little stranger. Some rules are not stated in the text, but we have an official story that associates the rule with a particular clause in the text. The state of Michigan may not abridge the freedom of speech. Mine, for example. The text, every lawyer knows that this is a rule of the First Amendment, even though the First Amendment clearly doesn't speak to the state of Michigan. At which point, every well-educated lawyer says, well, it's the 14th Amendment. This is the official story that associates this rule with the constitutional text. But if you took an untutored reader of English and put him or her in front of the First and 14th Amendments, I'm not sure that he or she would come up with the idea that this applied to Michigan. Next. The rule is not in the text. There is an official story that associates it with the text, and that story strains plausibility, but we go with it anyway because we know it's the right rule. This is the story, for example, of Bowling versus Sharp and the operation of equal protection norms against the federal government. Next. The rule is stated in the text, is not stated in the text. It is associated with a clause in the text. We don't even have an official story to explain why. But we don't mind. In fact, we generally don't even notice. Why can't the president constitutionally censor Fox News? Because of the First Amendment. There are many things in the Constitution that might be textually ambiguous. But if Congress means anything, or if Congress doesn't mean anything, it ought not to mean president. Next. The rule is not in the text. It is associated with something in the text. We say openly that the rule is not in the text, but we go ahead nonetheless and we perhaps associate it with a clause even though we acknowledge that the clause doesn't contain the rule. This was the status of the anti-commandeering rule, at least in the 1990s, when Justice O'Connor in New York versus United States and Justice Scalia in Prince both said, this is not a rule derived from the text, or even from the text of the 10th Amendment, but nonetheless the right rule. There are also some constitutional rules that we don't even know what clause to associate with. This is the continuum, and the continuum has a temporal dimension. The job of constitutional lawyers is to move propositions from the bottom of the page to the top in terms of their textuality. That is to say, to tell stories that make us more and more closely associate the rules with the text until we stop noticing that an untutored reader of English would not put the thing where we think we put it. This, again, is a story about the meanings being not quite transparent and not quite stable on the basis of the text. So, what are textualism and originalism really good for? Because they are really good for some things. Well, first, they're fun. I mean it. They are lots of fun. Who among us doesn't enjoy confronting a constitutional clause and thinking about the things the text might mean? Who among us doesn't enjoy the experience of putting himself or herself in the shoes of James Madison, confronting a serious political issue? Those things are good, not just as superficial fun, but as the kind of deep fun that fosters a sense of attachment to the regime. They don't really deliver the stability of meaning because we change. And they don't really deliver the uniformity of meaning because we disagree. I wish it weren't so, because originalism is so much fun. But wishing doesn't always make it so.
Thank you very much. I'm delighted to be on this panel today, and I'm going to present a defense of following the original meaning of the constitutional text. Mike Rappaport and I have put forward this defense in a book called Originalism and the Good Constitution. Here is our book. My publisher said that I should hold it up at every possible opportunity. The essence of our argument for originalism can be made with three relatively simple propositions. First, stringent supermajority rules are the best way to make a national constitution. That is, rules that are entrenched against the ordinary process of political change. Second, the United States Constitution was mainly made under such rules. And third, it's the original meaning that obtained that beneficial supermajoritarian consensus. It thus should be followed today. Note the structure of this defense. It defends originalism largely by reference to the likely consequences flowing from appropriate constitution making. It is consistent with perhaps the most common defense of originalism, that it ties political actors to rules, but to the virtue of rule following, it adds the rather substantial benefit that these rules are likely to be good. Let me expand on each of these points. First, a relatively stringent supermajoritarian rulemaking is the way to make a good constitution. It will not make a perfect constitution, nothing will. But it'll make a likely good one, and there's no superior way of making a constitution. Thus, as with a criminal trial process, we should ultimately accept its results as final. We can see the virtues of supermajoritarian rules for constitution making by contrasting constitution making by majority rule. While something close to majority rule is generally thought to be good for making ordinary legislation, permitting a majority to entrench constitutional rules would be problematic. First, constitutional norms can't be easily eliminated. Therefore, controversial entrenchments can be extremely divisive and partisan. Yet a majority, as we know, tends to enact divisive and partisan norms. Supermajority rules, however, permit only norms with substantial consensus and bipartisan support to be entrenched. A broad consensus for a constitution creates legitimacy, allegiance, and even affection as people start to treat these as their common bonds. The Constitution helps individuals, a consensus constitution, transcend their differences of geography, making them citizens of a single nation. The long-term nature of entrenchments also make it less likely that majorities will enact desirable entrenchments. Individuals have a problem in thinking about the future. They tend to think it'll be like the past. Hence, housing bubbles and stock market bubbles that go up and up until they don't. Supermajority rules compensate for this deficiency by restricting the agenda of proposals, creating, because only a few proposals have a realistic chance of passing, and that creates a stronger stream of information, improving deliberation. Even more significantly, a strict supermajority rule for passage and repeal of constitutional provisions creates a kind of veil of ignorance in which citizens aren't really very sure about where their position is going to be on these entrenched provisions that are going to have an enduring, enduring time over many, many years. Therefore, citizens and legislatures can't be as sure about where their position is going to be. Hence, they are more likely to consult the interest, the public interest, rather than their parochial interest in constructing constitutional provisions. This is not a mere abstract point, it's a very important point. People are, at the original Constitution, more likely to take account of, because they know the powers of the presidency are going to be defined for a very long time, they're going to consider not just who the next president is going to be, but what is the best way of parceling out the powers of the presidency on institutional grounds. That's the tremendous advantage of the veil of ignorance that the supermajority rule creates. Let's move to the second proposition now. The Constitution and its amendments have been passed under the kind of stringent, desirable supermajority rules that make for desirable constitution making. Pretty obvious in the amendment process, two-thirds of the House and Senate, three-quarters of the states. The original Constitution, there really needed to be a consensus at the Philadelphia Convention, and there were 9 states required by Article 7 of the Constitution to ratify the Constitution. Now, there's one way in which the original rules were really very problematic, the exclusion of African Americans and women. But supermajoritarian failure has been followed there by supermajoritarian correction in the form of the 13th, 14th, 15th, and 19th Amendments that have substantially corrected this very grave defect at the founding. It is these supermajority rules that created the big bang of our constitutional universe. To obtain a consensus of the convention, the nationalists had to compromise with those who were interested in more local forms of government. Hence, we have federalism. To obtain ratification in the state conventions, they had to agree, the supporters, to a Bill of Rights, and hence we have a Bill of Rights. So this is the really crucial aspect of creating some of the most admired provisions in the Constitution. The third step follows from my first two. The original meaning should be followed because it was the original meaning that got this consensus. It wasn't Ronald Dworkin's meaning. It wasn't Richard Posner's meaning. It was their meaning. This understanding includes not only the accepted meanings of the words of the time, but I think the interpretive rules of the time. One of the most important things, I think, in distinguishing the originalism from simple textualism in the Constitution is to recognize that the Constitution was not created ex nihilo, but against a background of interpretive rules. The Constitution declares itself to be law, and of course people understood that there were rules for interpreting law. And the Constitution actually refers to certain interpretive conventions in its own document. Thus, originalism depends on interpretive rules and is emphatically not a wooden or narrow textualism. There's a difference between originalism and textualism. The founding generation recognized that these rules would help resolve ambiguity and vagueness in text, and therefore to embrace originalism without embracing the interpretive rule is to look at a code without the decoding book. These original interpretive methods are one reason that I am somewhat, or at least not yet, persuaded of Randy's interesting distinction between construction and interpretation. The Constitution simply doesn't delegate a power to judges to construct constitutional norms, nor is there evidence at the time of the founding that the judges of the early republic thought that's what they were doing. They thought they were engaged in a process of interpretation. Instead, for hard cases, they chose the interpretation that was better supported. To be sure, judges may create doctrine for epistemic purposes that don't specifically track the text. For instance, perhaps discrete and insular minorities are a way to cash out the prohibition against caste legislation in the 14th Amendment. But the test of all doctrine remains the same. Is it the best way to realize the original meaning of the Constitution? Understanding the supermajoritarian origins of the Constitution helps us understand what's wrong for allowing judges to have discretion to update the Constitution or to consider for themselves good consequences. First, only a very small number of people are Supreme Court judges, a quite contrast to the supermajoritarian norms for constitution making. Second, the Supreme Court's drawn from a very narrow portion of society, elite lawyers who live in the most artificial town in the universe, Washington, D.C. And it's worse than that. They all now come from 2 law schools. It's maybe even worse than that. I mean, well, maybe at least they represent geographically 4 of the 5 boroughs of New York City. Finally, constitutional lawmaking is supermajoritarian, but the Supreme Court can change constitutional law by a bare majority. Some might think that judges would do better by following the original meaning as a presumption, but using other methods when they thought the original meaning was really, really bad. But judges employing a presumption would still be part of a judicial elite, and it would be hard for them to determine what are the really bad provisions in any fair-minded way. One general point is that in an all-too-human world of limitations, of constrained knowledge, of bias, we are better off having judges apply rules produced under conditions that represent the collective wisdom of the many, rather than rely on the ad hoc judgments of the few. I think the most fundamental objection to originalism is that it perpetuates an anachronistic political system. Perhaps the consensus nature of constitutional provisions made them desirable when they were enacted. But now, of course, they're all very old. They were made by people in wigs, after all. And they no longer produce the benefits they once did. But I think it's important to understand that a good constitution like ours has substantial resources to deal with change. First, the states themselves have very few restrictions on their powers absent congressional action. Their experiments to address social change in a republic with a free press can be adopted by other states if they're successful. Again, let me make this concrete. Freedom in the modern era has been greatly helped by federalism. For instance, take sexual freedom. Individuals went to tolerant jurisdictions, San Francisco, New York City, and there showed, both through their actions and through their writings, that society could tolerate a much more diverse set of sexual mores without the disorder that many feared. Secondly, another way of addressing constitutional change is Congress has substantial but not unlimited powers to legislate. And powers are often stated as principles, like the Commerce Clause. I completely agree with Randy. The meaning doesn't change, of course. But we recognize that because there's simply more interstate commerce, Congress has more substantial authority when there actually is interstate commerce to legislate. Finally, the Constitution creates an amendment process by which to replace provisions that have become outmoded. It's sometimes been thought, and I think maybe Richard Primus implied this, that the amendment process is just too difficult. But the historical record, I think, belies this. During the period when originalism was the dominant mode of interpretation, and that was throughout the 19th century, hugely important amendments were passed. The 16th Amendment, permitting the income tax. The 17th Amendment, permitting the direct election of senators. The 19th Amendment, giving the women the right to vote. And it's important to note that many of these amendments were passed against vested interests. For instance, the state legislatures gave the people the right to elect their own senators, giving up some of their power. And of course, men were largely represented in the state legislatures, and they agreed to dilute their voting power by giving the votes to women. So that shows, I think, how dramatic the changes can be. But of course, as non-originalism became powerful, the process fell into disuse for the enactment of profound social change. Article 5 has been largely fallen into, we were just not used now actually to using it, and of course that isn't surprising. It's non-originalism that has largely harmed our ability to rule ourselves through Article 5. If judges anticipate social change, they'll take the wind out of the sails of movements for constitutional amendments. And people, of course, will worry in a world of non-originalism that if they pass an amendment, they're just giving another blank check to judges. In short, it's originalism that protects the amendment process. If judges can change the Constitution, most people will put their energy into trying to get pliable judges appointed and trying to create a culture in which it's thought to be all right for judges to announce new constitutional rights. Of course, that isn't a hypothetical culture. That was our culture in a world where we had Griswold and Roe versus Wade, which were announced in ways that I think are completely unacceptable according to originalist reasoning. That culture has too recently been ours. Thus, originalism and the amendment process are mutually supportive. There can't be a normatively attractive originalism without an amendment process which permits each generation to change the Constitution. But there also can't be an effective amendment process without originalism. The amendment process and originalism march under a single banner. And what does that banner read? It reads, "Here we the people, and not we the elite judges rule." That is the culture that can be ours again in the future if originalism takes hold. I think we must never forget in talking about these complex questions of interpretation a fundamental truth, that our Constitution, like all other great political achievements of civilization, is not the work of we the people of any one time. Under a good constitution, the kind of constitution I'm describing, where its text is interpreted according to its original meaning, each generation can participate in adding their views to our fundamental law. Each generation also reaps the advantages of the works of the previous generation. Each generation can be assured that its work will be respected by the next, just as it respects the works of its own predecessors. Edmund Burke famously said that a good society, a great society, was a compact between the dead, the living, and the yet unborn. Our Constitution, properly understood, and understood according to its original meaning, translates that great insight into an effective legal mechanism to assure a flourishing society. Thank you very much.
Good morning. It is a pleasure to be here. Thank you, Judge Jones, my fellow panelists. I want to express my appreciation to the organizers for inviting me. I have great respect for the Federalist Society's commitment to open and robust debate, so it really is a genuine privilege for me to be here with you. In my remarks, I will try to advance two major arguments about originalism. The first is a descriptive argument about what it is that originalism holds or maintains. Now, of course, originalism is not a single unitary thesis, but rather a family of theses. So my descriptive claim is necessarily a generalization. So my descriptive generalization will be that, by and large, originalism has morphed over time from a theory of adjudication to a theory of law. And what I mean by these labels is this. First-generation originalists like Robert Bork, Ed Meese, and possibly the earlier faint-hearted Justice Scalia were advancing a normative theory regarding how judges should behave, what considerations they should rely upon when resolving constitutional disputes. In contrast, second-generation originalists like Stephen Calabresi, Michael Stokes Paulson, Sai Prakash, and probably the later robust-hearted Justice Scalia are advancing a theory regarding what the law is, or what makes it the case that a valid legal norm has this content rather than that content. That's abstract, so the first part of my remarks will be devoted to fleshing out this claim distinction. And I should say that neither of my originalist co-panelists, Professors Randy Barnett or John McGinnis, share exactly this Calabresian perspective, so I'll happily address their views in discussion or I don't know, offline, as they say. But I'll basically omit consideration of them from my remarks. And my second major argument will be that when pitched or construed as a theory of law, originalism confronts formidable objections. Actually, originalism, I think, does no better when conceived as a theory of adjudication, but that won't be the focus of my remarks, because as I say, I think the center of gravity of contemporary originalism is as a theory of law. So the basic idea is this: insofar as originalism has morphed into an account of what the law is, as distinct from but not incompatible with a theory of how judges should decide cases, then it necessarily makes legal philosophy relevant. I know that's going to pain some people to hear it, but I think that that's the necessary upshot of what originalism maintains. And in a nutshell, philosophy of law doesn't give originalism the support that it needs. Okay, so that's the preview. Let me start by offering a thumbnail sketch of the history of modern originalism. Like everybody else, I take it that originalism in its modern guise arose as a response to actual or perceived abuses by the Warren and Burger courts. Critics didn't like the results that the courts had reached, and they didn't like the way that the courts had reached them. Critics complained that the liberal justices just weren't doing law. Instead of engaging in legal reasoning, they were engaging in moral reasoning, or navel-gazing, or making it up. So Robert Bork, in his classic 1971 article, offered a prescription for the evil that he and other Warren Court critics had diagnosed. And this is what he said: where constitutional materials do not clearly specify the value to be preferred, there is no principled way to prefer any claimed human value to any other. Therefore, the judge must stick close to the text and the history and their fair implications. What I want to draw attention to is that this statement is a statement about how judges should behave. They ought to stick close to the text and the original intentions. 15 years later, Ed Meese defended the Reagan administration's jurisprudence of original intention on the ground that, quote, only the sense in which the Constitution was accepted and ratified by the nation, and only the sense in which laws were drafted and passed, provide a solid foundation for adjudication. The significance of these passages will become a little clearer in a few moments when I introduce passages from contemporary originalists. But I hope these passages just provide some sort of tentative provisional support for my claim that originalism began as guidance or as an injunction regarding how to do something, namely how judges should reach decisions in constitutional cases. Consistent with this perspective, originalism is often described as a method for deciding constitutional cases. That quote just comes from Jonathan Macy in a speech he gave to a Federalist Society symposium a bunch of years ago. Last night, Judge Sykes described originalism as a method of constitutional interpretation. Right? This is what we might say loosely as practical reasoning or practical guidance, how you should do something. Now, as you all know, early defenses of originalism provoked several objections. Among other things, critics charged that the focus on collective intentions is misguided for one reason or another, perhaps because it's incoherent, and that the originalist injunction does not promise the constraint on judicial willfulness and subjectivity that early originalists seemed to promise. In response to criticisms such as these and others, the dominant touchstone for originalists shifted from the intentions of the framers to what came to be known as original public meaning. Randy already referenced this change. Okay, so far, so familiar, I think. Now, I would like to draw your attention to an aspect of this narrative that is widely underappreciated. The aspect that I would like to foreground concerns a shift in the dominant rationale or justification for originalism. By and large, first-generation originalists advocated that judges should hew closely to text and original intention because doing so would significantly constrain judges and curb their predilections for giving effect to their own substantive value judgments. In contrast, by and large, second-generation originalists advocated that judges should follow the original public meaning of the text because the original public meaning of the text constitutes the law. For example, in an article published 20 years ago in the Yale Law Journal, Stephen Calabresi and Sai Prakash explained that, quote, originalists do not give priority to the plain dictionary meaning of the Constitution's text because they like grammar more than history. They give priority to it because they believe that it and it alone is law. To repeat, the plain dictionary meaning of the Constitution's text and it alone is law. And in an article published last year, George Mason's Nelson Lund endorsed what he described as a very simple-minded view of judicial duty in constitutional cases. That simple-minded view, which he said is originalism, is that, quote, Supreme Court justices should just apply the law. And what is the law? It is what the words of the constitutional text, he said, would reasonably have been understood to mean at the time it was adopted. These passages are not unusual. I could give you many more, but we don't have that much time. My suggestion, in short, is that the usual takeaway from the canned narrative that I have offered misses something of great importance. The familiar telling of the narrative of originalism's evolution over time strongly emphasizes the change in originalist thinking regarding what it is that judges should follow. They should follow public meaning as opposed to framers' intentions. The overlooked part of the story concerns the change in originalist thinking regarding why it is that we should follow it. Whereas originalist writing in the 70s and 80s mostly advanced claims regarding what judges should do or how they should reach decisions, originalist theorizing starting in the 1990s increasingly advanced claims regarding what the law is. And this is the difference I mean to capture in describing early originalism as a theory of adjudication and contemporary originalism as predominantly a theory of law. I should say parenthetically that John McGinnis and Michael Rappaport's view is actually a form of older originalism. It's a claim about how judges should decide things, and there's a reason for it. The reason is not the older reason that it constrains subjectivity, but a different reason, but still a forward-looking consideration, one of producing better consequences. Do this, because if you do this, it's going to produce better consequences. I hope that you realize that the distinction I'm drawing is that that's a different sort of account than do this because this is the law. Now you might think, well, of course it's the law. I'll be discussing that. You might also think that the change in what I perceive as a change in originalist thinking is nothing more than a change in manner of exposition. You might think that first-generation originalists who spoke in terms of what judges should do were implicitly relying upon claims about what the law is. You might suppose that when theorists like Bork and Mies enjoined justices to stick close to the original intentions of the text's authors, they were really thinking, stick close to the original intentions because the original intentions constitute what the law is. So 3 things in response. First, the objection that I will raise shortly to the contemporary originalist theory of law does not depend upon my persuading you that older originalists were up to something different. I believe that they were, but if you believe that older originalists were advancing a theory of law and not only of adjudication, then the upshot of my argument is, of course, well, so much the worse for them, too. Second, it is very much worth appreciating that normative arguments about constitutional interpretation frequently, perhaps typically, sound in a register of what judges should do and not what the law is, and in circumstances when it's not really plausible that the accounts that on their face are advice about what judges should do are really implicitly views about what the law is. So take John Hart Ely's celebrated representation reinforcement theory advanced in his Democracy and Distrust. This reads as a theory about when judges should and should not intervene, rather than as a theory about what our constitutional law provides of its own force. So it's perhaps revealing that the book is subtitled A Theory of Judicial Review and not a theory of constitutional law. Also, Justice Breyer's recent book quite clearly is an account of what judges should do. They should help make our law more effective. That account is not plausibly an account of what are the determinants of legal norms. What is it that makes the legal norms have the content that they have prior to the act of judicial interpretation? So it is consistent with their historical context, and it's consistent with a very dominant trend in constitutional theory for originalists to have been thinking in terms of the considerations upon which judges should act. It's anachronistic to think that people who speak in terms of what judges should do must necessarily be relying upon an implicit jurisprudential claim about what it is that makes legal norms what they are, and therefore what the law is. And third, there is a reason why originalists started to maintain in very explicit terms that the original meaning of the constitutional text determines or constitutes what the constitutional law is. This development is not accidental or unimportant. This development arose, I think, because it helped underwrite an increasingly prominent strain in judicial and scholarly defenses of originalism. Namely, if I may say so, it's dogmatism. I will refrain from offering examples. A dogmatic attachment to originalism is difficult to maintain insofar as the originalist normative prescription, how you should behave, is based on claims about what's going to best constrain judicial subjectivity. And that's for a couple of reasons. First, it is frankly uncertain to what extent the early originalist prescription does in fact constrain judges. Second, minimizing judicial subjectivity, while certainly a worthy value, is plausibly not the only value that should matter to us. So insofar as the question is, how should judges behave, or how should we evaluate what they do, it's very plausible that there are going to be other values which necessarily are brought to the table. They should promote democracy, they should promote justice, they should promote stability. My point is not to take sides in this dispute. My point is that originalists who tend toward dogmatism would not wish to find themselves engaged in this dispute at all. Insofar as the debate over proper judicial behavior turns upon evaluative and predictive questions, then in a pluralistic legal and political culture, it just is inescapably so, I think, that these are going to be matters over which reasonable people can differ. But if originalism is grounded in a claim about what it is that makes law what it is, and what it is that determines the content of our legal norms, then it seems that this is the sort of question that by its nature admits of only one answer, which is, I think, what gives greater strength to contemporary originalism. So when dogmatic originalism is ascendant in our legal culture, we should expect it to be underwritten by claims bordering on the metaphysical about the sole grounds of legal norms, and not claims grounded in the messy stuff of political theory about the facts and factors that judges should entertain. When I say it's bordering on the metaphysical, this is what I mean. When you see an argument that says, it is the nature of law that, or it is the nature of constitutions that, or it is the nature of interpretation that, these are metaphysical claims. Okay, so I believe that the central theoretical contention of contemporary originalism holds that the original semantic or communicative content of the text, what the text means or says, is the law. Or to put it another way, the dominant strand of contemporary originalism maintains that the legal content of the constitutional text is reducible or fully determined by its semantic content. The legal content, what the law is fully determined by what the text means, is the dominant claim of contemporary originalism. So it remains only to ask whether this contention is true. This is the type of claim that, as I say, necessarily invites intervention by legal theorists. So is it true? I believe that it's not true. I won't be able to build a compelling case for that proposition in the few minutes remaining to me, in part because it will require immersion in the 2 minutes remaining to me. So my ambition must be more modest. I'm going to mount an admittedly scattershot attack on this jurisprudential claim, hoping to persuade at least some of you that the claim is, at a minimum, substantive and controversial and should not be blithely assumed. So, here's the scattershot attack. Well, first, because I anticipate that many of you will think it's self-evident that the legal content is fully determined by the semantic content, I should remind you that there's another claim that many people think is self-evident about law, but it's unquestionably false. The claim I have in mind is that, as Justice Scalia put it in his 1997 book, Matter of Interpretation, the text of the Constitution is the law. This is something people say all the time. It just seems like obvious. It's said by originalists and non-originalists alike. The quintessential non-originalist David Strauss wrote in his 2011 book, The Living Constitution, that everyone, originalist or not, believes the text of the Constitution is law. Well, everyone doesn't believe it because I don't believe it, and I don't believe it because it's false. Text and law are two different things. Text cannot be law. Text is an arrangement of lexical entities. Laws are norms. They are rights and duties and permissions and powers, and they are just different sorts of things. So just, for example, we believe that two different texts can actually have the same law. One text might say, no person under 18, and the other one might say, persons only 18 and above. Those are different texts, but plausibly they're the very same law, so text and law are not the same. We also think it possible that a committee of style can make changes to the text without thereby making changes to the law. So text is not law. Here's another point. It's uncontroversially false that law just is the meaning of an authoritative text. There is, after all, customary law. Or how about this, even putting aside customary law and focusing only on forms of law that have textual roots, it's still uncontroversially false that the legal norms to which texts give rise are fully determined by the text's meaning or semantic or communicative content. Common law decisions are text-based, and yet the law that they give rise to is not the communicative content of the text, but instead something like the ratio decidendi. Moving from American constitutional theory to general jurisprudence, there is no widely accepted general jurisprudential view, not natural law theory, not Harshan positivism, not Dworkinian interpretivism, pursuant to which law is necessarily the semantic content of a text. It is the orthodox view among lawyers in some contemporary legal systems with which we are familiar that constitutional law is not fully constituted by the meaning of a constitutional text. That is the orthodox view in Canada, for example. And there are many examples from US constitutional law in which it is widely believed that correct statements of the law are not, and not merely erroneous judicial precedents, is other than the meaning of an associated textual provision. The constitutional law of sovereign immunity is not identical to the original public meaning of the 11th Amendment. Same with the First Amendment. Richard Primus has given us many good examples. So think about what precisely is the constitutional status of the principle of separation of powers, or the anti-commandeering principle. Aren't these in some sense true principles? And if they are principles, what are they other than principles of constitutional law? And yet, they do not correspond to the meaning of any provision of the constitutional text. And we all believe that it is unconstitutional for a state to secede. Again, an example Richard gave, no text associates it. So it is simply not true that our constitutional law is fully determined by the semantic content of the text. What is it determined by? Well, that's a hard question. It's a really hard question, and that shouldn't surprise us, because figuring out what law is and figuring out what determines the contents of legal norms is an incredibly complex matter. I don't have an answer for you. I think, do original meanings matter? Absolutely they do. Do they matter a lot? Yes. Is our law intimately related to the meanings of the text? Yes, it is. But modern originalists need more than intimacy. They need identity. And that is something to which they are not entitled, I believe. Thank you.
Okay, Professor Barnett, do you have any comments?
Yeah, I have a couple.
But I mean, in the interest of allowing the audience to do questions, no more than about 5 minutes.
I'll try real hard. I have a couple brief things. Just a brief thing about John and Mitch, and then I have a little more to say about Richard. I'm thinking about what they're saying, not with who their names are. So it all basically turns around this distinction between interpretation and construction that I was making before, and how if you don't have that as part of your working toolkit, you can be thrown off by arguments that confuse one thing with another thing. Briefly, with respect to John, John is one of the skeptics about this interpretation-construction distinction. I think partly it's the word construction that bothers folks like John a lot, but then immediately after he expresses his skepticism, he says that, of course, we need implementing rules in order to put into effect what the Constitution says, and all these doctrines are not in the Constitution itself. And so he's immediately pointing to the activity I'm calling construction. He doesn't like to call it construction. He has an additional theory that we can get by with all the rules of construction that existed at the time the Constitution was enacted. Well, that's an interesting theory about how we do construction by identifying those implementing rules from back then. Whether that can work or not is another question beyond the scope of this particular panel. But we just have to have conceptually in our head the difference between figuring out what the meaning of the words on the page are, and then secondarily how we put the meaning of the words, how we give legal effect to the meaning of the words. Those are just two separate activities. They are highly related to each other, And he said, he says one simple rule should govern this area of implementing rules. Is it the best way to realize the original meaning of the Constitution? I agree with him entirely. That is what it would mean by adopting rules of construction that are within the spirit of the Constitution, even though perhaps not dictated by the letter of the Constitution. It's an age-old effort that judges have done, and they did, in fact, oftentimes self-consciously refer to construction, as St. George Tucker does this, as opposed to interpretation way back in the day. So that's all I'll say. I think John and I just aren't disagreeing about as much as he thinks we are, and I wish one day to make him believe that. All right, so it's a fond hope I have. Mitch, I'll say just briefly, a lot of his argument, and I'm more familiar with his arguments in writing, and we've debated and we've been in other forums, so I'm quite familiar with his positions. He could only scratch the surface of what they are here today. He places an awful lot of premium on defining originalism to be X, and so he has his own definition of what originalism is, and then if you don't believe the thing that he says is X and he says X is wrong, then you're not really an originalist. So that's why he didn't talk about me and he didn't talk about John, because we don't fit his definition of X, of originalism. But that's kind of an odd way of going about critiquing a theory. But what is his X? What is it that he thinks all originalists must be saying? And he has some evidence for the fact that some originalists have said things like this in the past. I'm not saying he's making this up. And that is that originalists must be saying that original meaning of the text is the sole ground of law. I'm just giving some quotes from what he said. It and it alone is law, or that the legal content is fully determined by the text of the Constitution. These are things he says. He said originalism, his last words was, needs identity of the original meaning with law. These are all his criteria of what an originalist must be thinking and must be saying, and I just think that this completely is not what most originalists, even if they sometimes talk like that, it's not really what they think, and if they do talk like that, it's because they are not really fully comprehending the difference between interpretation and construction, that interpretation is figuring out what the meaning of the text is, and that meaning is fixed at the time it's enacted. There's a fixed meaning at the time of enactment, and that fixed meaning contributes to what the law is for a variety of reasons that need to be added to the story beyond the meaning of the text itself. So I think that Mitch's his ultimate jurisprudential position is right. It's just that he attacks to some degree. He makes up a theory of originalism that he then refutes, and then anybody who doesn't fit that theory isn't really an originalist, and that's kind of an interesting. I think it's a somewhat suspect way of going about doing a critique of a practice or a tradition. All right, so finally, Richard. His chart was beautiful. His chart was his flow chart of all the different things. First he gives you the text, and then he says, we can tell a story about this other proposition, which is not clearly in the text. Well, yeah, but mostly that story is, he left out of his flow chart because it wasn't part of his talk. First, we start with what the meaning of the text part of is. And then we go from the meaning of the text to a story, he calls a story, which I would call a process of construction, in which we give legal effect to what the text says, and sometimes the propositions that he then has are part of that story. But it's not just any old story. It's a story that gives effect to the meaning of the text, and it's connected to the meaning of the text. And if it isn't connected to the meaning of the text, then you've got a real problem from an originalist standpoint, but you don't if you're not an originalist. Now, one of the reasons why the legal realists, for example, really attacked and basically destroyed the interpretation-construction distinction, it was because they wanted to make everything into construction. In a way, that flow chart kind of does. So he's using that flow chart to show how contingent the propositions of law is that we follow, and how they don't seem to connect up with the text. But that's a way of delegitimating the text. That's what that technique actually does. And the reason why the text needs to be delegitimated is not because it has this open-ended meaning that we can disagree about, and of course sometimes we do disagree about, and Richard also stressed all the disagreements that we have. The reason why that text needs to be delegitimated is because it actually does mean something. And the people who are delegitimating it don't like what it means. They don't agree with what it means. They don't like the original Constitution. And they have good reasons to. Most of them are, European social democratic in their views, or they believe in they really believe that, like my dear friend Sandy Levinson loves parliamentary democracy. He thinks that's the way you ought to go. And of course, there's a lot of nice people who live in countries that are governed that way. But we don't have that system. In our country, we have a different system. The founders rejected, they actually experienced parliamentary majoritarianism in the states and in the articles, under the Articles of Confederation. They didn't like it, so they devised a different system. And many people for a very long time haven't liked the system. So they have to get, and so if that text was so open-ended and so malleable and so subject to dispute, and the historical meaning of the words on the page was so open-ended and so malleable and so subject to different opinions, you would not have to get rid of it. You would not have to get rid of the Second Amendment. You would not have to get rid of the Commerce Clause. You would not have to get rid of the Necessary and Proper Clause. You would not have to get rid of the Contracts Clause. You would not have to get rid of the Ninth Amendment. You would not have to get rid of the Privileges and Immunities Clause of the 14th Amendment. You would not have to get rid of the Origination Clause, most recently, where the revenue bills are supposed to originate in the House, but we know that they're now originating from the Senate. You wouldn't have to get rid of all of these clauses if they didn't mean anything. You could just follow them and give them the meaning you want. But the meaning that has been settled upon for each one of the lost clauses of the Constitution is a meaning that essentially means nothing, and we're just going to move on. And we function on partial Constitution. And all I'm saying is a question of meaning. It's not because they don't mean anything. It's because they mean something. Now, they don't, and that's why they had to get rid of. And they don't mean everything, though, and I'll just close with that. One other little point. One other little point, and that is that he talks about, he quoted this quote about constitutional lawyers are paid to masquerade as historians. No, this is just a, this is, I can't, it's a cheap shot, not by you actually quoted Gerard for saying it, but it's, ask a historian what the meaning of a legal text is in history, and you know what? Unless they're a trained lawyer, they're not going to be able to tell you something that's very helpful about it. The historian stock and trade is not legal interpretation. They're very bad at it. They just say stupid things about legal interpretation while they're saying wonderful things about the periods that they're studying. You need to be a lawyer in order to interpret text, and that's true also if you're interpreting old text. And the interpretation of old text is a legal art. And every lawyer in this room interprets old texts. You do it for a living, and you know how to do it. Now, you know, sometimes it's more difficult than others, but it's certainly possible. That is a legal thing, and when historians try to do it, they produce stupid stuff. Even if they're in amicus briefs to the Supreme Court, they're still dumb. So, I don't think originalists need to be historians. Originalists need to be lawyers, and lawyers that are operating throughout different periods of time, looking at the relevant context. Thank you, Judge.
So I don't think that the people who do something different from what I do are dumb. And I don't think that someone who grew up basically down the street from me, like Randy, is a European social democrat. And I don't think that the people who disagree with my view are people who dislike the text of the Constitution. I think we all pretty much like, even love the text of the Constitution. I'm on board with Randy in what he says about construction being the thing that ties together the text with propositions of law that untutored readers of the text wouldn't recognize as being there. To be tutored is to know the set of constructions. That's what it means. The point of the exercise is that you need something beyond the text, like that set of constructions, to get there. And that set of constructions has many, many bases, some of which are accounts of original meaning, some of which are accounts of structure, some of which are normative accounts. And we have a tendency to make all of these things hang together, even if we have to push and pull and cajole a little bit on some of those things to get them there. One of the things that really makes the line up, the thing that decides how we're going to make them line up, usually is case law. That is to say, we have a wide open debate about the meaning of the Second Amendment or the Equal Protection Clause, but then when you go to decide the next case, the thing that tells you what to do with that debate and with the materials in it is a case. Right? We don't rehave the whole discussion about the meaning of the Second Amendment because now we just cite Heller. Heller is what makes the Second Amendment determinate. I just want to then say one other thing about, raised by something that John said. John, toward the end, said something about Burke and the good society and the compact among generations. This is a call for tradition and traditionalism in decision making. And I'm all for that. one of my problems with originalism is that it's highly in tension with that, right? Like as our friend Tom Merrill points out, originalism is not Burkean. Originalism is Borkian. And those are not the same. Tradition is about slow incremental change on something basically continuous. It is about doing today more or less what was done yesterday, and yesterday more or less what was done the day before that, and so on and so on and so forth. Originalism is about holding today to the standard of a time that is not yesterday, but many, 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 many yesterdays ago, under substantially different conditions. It is about sweeping away dross and error that has accumulated over time through a bunch of slow changes and a return to fundamentals. Right? And the pejorative term for this is, in fact, fundamentalism. Right? Tradition and originalism are not friends. We like to put them together for the same reason that we like the founders to share our values. We want to like all these things, and we want them to hang together. But originalism comes as a theory of anti-traditional change much of the time. It comes to restore something that either was or that we imagine was in place of the thing that we have actually inherited. And a large part of my skepticism of originalism is that I am skeptical of tools of social change, substantial social change, that judges are asked to deploy. Done.
All right, thank you.
Okay, well, let me go in sort of reverse order, because I actually agreed with much of what Mitch Berman had to say, which surprised me a little. But in the sense that I disagree in one sense. I think that people with normative theories, which I'm presenting of law, often have theories not of only adjudication, but of how all political actors should decide the Constitution. But I do agree, I'm presenting a rather anti-metaphysical view of why we should be originalists, and I think the idea that we just should be originalists because it's the law has some problems. One is that at least I think there are a lot of people in jail because of a non-originalist meaning of the Constitution, and that at least requires some explanation, and it does seem that most of our society accepts what the Supreme Court says, even if it says we're not being originalists, as of course it did essentially in Brown versus Board of Education. So I do think there are substantial problems with that simple theory of why to be an originalist. With respect to Richard Primus, I think we do have a very basic disagreement about the nature of truth, I think, ultimately. He describes that we are telling stories. I actually think that it is possible to understand what the meaning of a text was at the time. It's not a story, it's actually the truth. And it seems to me absolutely essential that we have a culture of truth-seeking. And I think ultimately that is in some sense what the debate about originalism is, that it's not surprising that in a world of the 1960s where there was a kind of relativism, a kind of very strong relativism took hold, originalism just disappeared. In a world where there's deconstruction becomes a reigning theory in all sorts of our departments in universities. Well, of course we're just telling stories there, and that completely destabilizes the Constitution. And so what's absolutely crucial is to bring back, as part of the culture of originalism, a culture of investigation of truth. I'm quite optimistic about that. I think actually some of Randy's work has shown the real power that we can find out what the meaning of the Commerce Clause is. And I think with big data and technology, we actually may be in a better position to, in a very systematic way, investigate historical meanings. But I think the most important thing is to insist that we're telling the truth about it. Just a brief point about traditionalism. I'm not arguing for simply a Constitution to be understood as a tradition. The argument for Burke is this is a mechanism that non-originalism has destroyed, the amendment process that allows every generation to participate in a way that's going to create a good Constitution rather than through judges or non-Article 5 ways of changing the Constitution. With Randy, well, again, I think like Randy, I hope to persuade him that we don't have as much difference between us. And I'd like to focus on what his statement at the end of his response is that interpretation is the legal art. And I completely agree with that. But that means that interpretation includes all sorts of legal rules. There's just a lot more information out there that actually allows us, by investigating it, to find right answers to hard questions. And that not only includes the meaning of the words, but as I suggested, it's very hard, I think, to look, as any lawyer understands, a legal text without understanding the interpretive rules and the methods of interpreting that text that came before it. And by including those, I think we are likely to cash out a better meaning of the text and not have resort to any extra constitutional kinds of construction. Because I think that's the real, if there is a difference, I tend to think that any methods of construing the Constitution are methods of interpreting the Constitution because they are found either within the Constitution or the rules that were understood to interpret it.
Thank you.
I won't say anything.
Oh, well, all right. Okay, well, I think we'll open the podium up to questions.
Can you hear me?
Yeah.
Now we can. Speak directly into the mic.
Okay, I'll speak directly into the
Thanks.
mic. I'm a first-year law student. I have a question that I'm hoping, in particular, Professor Primus will answer, but anybody else who would like to comment, I'd welcome that as well. My question concerns the difference between constitutional interpretation and factual interpretation. So if you read the majority and dissenting opinions in a case, often you wonder if they're even ruling on the same facts. I think it's possible for two people to agree on what the original public meaning of, the 14th Amendment is, for example, to ban laws that enforce or caste systems, but disagree on how they view the facts today. So they, maybe in 1868 people didn't see the treatment of women as creating a caste system, but nowadays we do, and the same original principle could be applied, but get very different results. And do you think that could lead to changes in the outcomes of originalist interpretations?
So I'll answer the question, though I think other people should also, because I don't think it's particularly, in substance, I don't think it's particularly addressed to me. It seems to me that people can have the same or different interpretations at both of those levels. And I think that's true whether the principle that you use to give meaning to the 14th Amendment is originalism or anything else, right? No matter what, almost every method, certainly any plausible method, is going to have within it room for differing understandings of what something as capacious as the 14th Amendment means. And then, life being complicated, different people are going to disagree about applications. We're also going to agree most of the time. That is to say, the number of cases where we make that disagreement as they actually arrive is relatively small. They're just salient. But the disagreement occurs at both phases, sure.
My name is Gerald Walpin, and I'm a member of the Federal Society Board of Visitors. And as long as everybody's advertising their books, mine was sold yesterday. It's called The Supreme Court versus the Constitution, and is a practical book for laymen, but lawyers could also understand it. I have a question for Richard. I wrote down some of his comments, which I found very interesting. He said that the suggestion he makes is a practical one. We are the people governing. Because we change, the Constitution invites judges to decide what is best now. If that were the rule in construing and applying the Constitution, how do you reconcile that with the fact that our founding fathers spent a great deal of time debating almost every word of the Constitution and created a very complex amending process to be followed in the future, making it difficult to change it, when, if it wished to mean what you say, it could simply have said in a few words, one paragraph, we are creating a new country in which we want the people to govern, and in order to decide what is fair in the future, we give that power to 5 or 9 justices.
So the first thing is that what you say I said isn't quite what I said. It's not my position. It's the position that the person in my chair is supposed to have, but it isn't actually what I said. I didn't say that the Constitution invites judges to do that. I said that originalism invites judges to do that, almost forces them to, which I think is a bad thing, not a good thing. In other words, my position isn't what judges ought to do is decide what's sensible and then do it. My position is that originalism, if judges are asked to implement it, has the effect of causing judges to do that, because it throws them onto a sea of highly indeterminate, contestable meanings and forces them to choose. And when people of good faith are forced to choose in situations of ambiguity, they'll be drawn toward what they think are the sensible choices. I would not want them to be drawn toward what they think are the insensible choices. And they'll disagree about what those are. So the point isn't that it's a good thing for judges to do what they think makes sense. The point is judges can't help doing otherwise if the method that they're implementing is a method that that puts them in the house of a lot of ambiguity. The question, though, can still stand. That is to say, if there is indeterminacy in judging under the Constitution by originalism or even by some other method, why would the founders have so carefully attended to what they wrote? Well, one answer is it's not all or nothing. That is to say, all lawmaking is an attempt to control the future. Constitution making, in part because it's supermajoritarian, as John says, is one of the most vigorous forms of attempt to control the future. The problem is that the future resists control. It is susceptible to some influence. It matters that the Constitution says X instead of Y for lots of things. It mattered a lot at the beginning of the Republic. It mattered more and less over time. It matters. It just isn't capable of fully determining, no matter how much they might have wanted to. And then here's, I think, the most important insight that follows from this. I assume that the founders were smart. And because I assume they were smart, I assume that they know what I know about the limits of any generation's practical ability to control the future. That is to say, I assume that they knew that things that they did would set certain things in motion, would develop certain constraints, would make some things easier and some things harder, but could not possibly have the effect of getting people perpetually to follow a particular set of rules in the way that they imagined them. It was worth the effort for the influence that they had, a pretty beneficial influence, all things considered. But I don't think that we should attribute to them the view that they thought that their efforts could actually determine results for into this century on the basis of recovery of their meanings. I think it imagines them as being people of simpler minds than they actually were to think that they would have thought that.
Yes, sir.
My name is Paul Kamenar. I do not have a book, but I do have a brief that I filed this week on behalf of 40 members of Congress on the Origination Clause, and I would like to direct this to Professor Berman and Primus. The Origination Clause is very clear on the text. All bills for raising revenue shall originate in the House of Representatives, but the Senate may amend or concur as on other bills. Pending before the D.C. Circuit is whether or not Obamacare, which raises $468 billion in revenue, originated in the Senate, where Harry Reid had the bill. What happened was you had a House bill, 2-page bill, that provided tax credits for veterans who buy homes. That bill went to the Senate. Harry Reid tore off the bill number, put it on the 2,000-page bill, which is Obamacare, shipped it back to the Democratic House controlled by Pelosi. They passed it without a Republican vote. And then the Senate says with a straight face, oh, This bill didn't originate in the Senate, it originated in the House. Look at the House bill number on top of it. So I would like to ask the two professors, how should the Court of Appeals interpret the text of the Origination Clause, which seems pretty clear on the text of the face, that if you go back to the originalism and the founders, they were very clear that any revenue raising had to be done by the House closest to the people. It's both a separation of powers issue and one that the Constitution would not have been ratified if it were not for that provision.
I really appreciate the question because it enables me to clarify something of importance. I don't think non-originalism and living constitutionalism are synonyms. I think non-originalism is the denial of originalism. And I do believe that, by and large, originalism is a very strong thesis. So I think non-originalism sort of owns the field. I do not think that non-originalists believe that original meanings and understandings and intentions are irrelevant. Very, very far from it. We're in the, I think, enviable position of being able to say, yeah, they matter a lot. And in some cases, they're going to be dispositive. And there are other factors, too. Tradition is partly a contributor to the content of our law, for example. So, the answer to your question, no, I don't know. You know, that's a legal question, not a legal theoretical question. And I think that I would have to spend a lot more time with the relevant materials to figure out what I think the right answer is as a matter of constitutional law. Based on what you've told me, your position strikes me off the cuff as really quite plausible. I can imagine other considerations as well. So, as a non-originalist, if it turns out that your originalist argument in this particular case wins the day and is the right one, my feeling is, could well be.
I agree that it's a question where I would want to know a bunch more about the particular legal materials in order to know the best answer. I think that it's probably a case where original meanings in text may cut in opposite directions, because the text could easily support the bill as enacted, right? The question was, what does origination mean and what is a bill? And if a bill is formally the bill with this number, well, then it originated in the House. If a bill is substantively this set of provisions, well, then it probably originated somewhere else. And one of the things that I would need to know is how many other parts of the US statute code are there under similar procedures that just didn't attract attention because they weren't as controversial as this one. And then I would want to know, what I'm saying now is I recognize controversial, but I think sensible nonetheless. The Origination Clause exists because of a sense of separate functions of the House and the Senate that made a lot of sense in the 18th century when there were different methods of election and different voting patterns in the houses and so forth. Today it makes a big difference practically when the two chambers are composed of have majorities of different parties. The underlying theory isn't really quite there anymore. The point here is that if the argument is a structural argument about the functions of the houses, it's weaker today than it was then. So we have multiple factors, right? There's text, which could easily support the bill. There's the history of practice. I'd want to count statutes. There's a certain kind of original meaning, which seems to cut against the bill. There's structure, which, given the way the House and the Senate actually work today in the reproduction of function, probably doesn't cut against the bill. And then there's the question of how much deference judges give to elected officials and elected majorities. That's how I would set up the question, and how to cash those things out and bring them home is something that I wouldn't want to opine upon on a complicated legal question without a lot of further thought.
Let me just object to one bit of what Richard Primus said about looking at the practice. I'm actually, I think, an originalist who believes that there is precedent. I'm a little cautious, though, about having practice of the branches that is without, at least one of the advantages of judicial review is to make sure the foxes aren't guarding the hen houses. And one great concern about practice, and I think we'll see that in the Noel Canning case, is that it may be that the Congress and the President are actually, in some sense, in a conspiracy. They're actually doing things that are good for them, but not good for the people. And so I think it's a very dangerous practice if constitutional law gives a lot of weight to the practices of the branches. In some sense, the Constitution is an anti-conspiracy document. By separating out powers, it protects our liberty.
Hi, my name's Erica Myers. It seems to me possible that you're actually all in violent agreement, especially answering the last question. The panel members who are critical of originalism and textualism seem to be suggesting that their criticisms are of the idea that originalism and textualism are the only legitimate tools of constitutional interpretation, but that you wouldn't deny that they are legitimate tools of constitutional interpretation. And similarly, for the supporters of originalism and textualism on the panel, are you actually taking the position that originalism and textualism are the only legitimate tools of constitutional interpretation, or are you simply arguing that they are legitimate tools to be used among other tools?
This is a great clarifying question. I hope what I say will more or less be accepted by the other people on the panel, but obviously not. They're free to disagree. I think that I think originalists claim that originalism is the method of constitutional interpretation, which means figuring out the words on the page mean. Then I would then separate the implementation of those rules, which cannot ordinarily be originalist and incomplete because the information is such as it is, and you need more in order to come up with doctrine, so that whatever you call that more and wherever you get that more from, you're no longer doing the meaning, you're no longer ascertaining the meaning of the words on the page. But originalism is the way to do the meaning of the words on the page. And I think what separates originalists from non-originalists is not that non-originalists deny that meaning is relevant. It's that I think they think other factors can trump that meaning. These other considerations or modalities of thought, they think, on many cases, can supersede that original meaning. And I think an originalist thinks that it cannot supersede that original meaning unless that originalist is working with a doctrine of precedent in which the precedents can supersede original meaning under certain circumstances. And so that divides originalists about the role of precedent. So I think just as a classification technique, exercise, I think this is a useful one.
I want to divide text and original meanings. I definitely think that text is an important and valid determiner of constitutional meaning and constitutional outcomes. I think we need to be careful about what we mean by that, right? Because it turns out that text means a lot of things that the untutored reader wouldn't know it meant. But nonetheless, I don't imagine a practice of constitutional interpretation without text, and I don't imagine sensible constitutional decision-making without text because of many functions that text executes. Notice, transparency, constraint, right? This, I think, divides me from Mitch a little bit. That is to say, I think that I'm more skeptical of the wisdom of making decisions on the basis of original meanings than he is. I'm not completely skeptical. I think there are cases in which original meanings are properly not just influential but binding, right? I think, for example, that original meanings are binding in the case of recently enacted provisions simply for reasons of democratic authority. And I think the democratic authority wanes over the course of time and wanes very, very far when no one who participated in the decision is governed by the decision anymore. Right? So that means that certainly for a time original meanings are important and indeed binding, but not always, not in every case. This also explains part of an answer to a previous question. A generation is worth making law for, even if you can't make law forever.
I just have a question, I guess. Ilya can close with the last question, but if it's so difficult to interpret the Constitution, which I think is one of the clearest, greatest documents in world history in trying to frame a government of laws and not of men, how come it's so difficult to interpret that, but what about recent Supreme Court decisions? It seems to me that the decisions of 9 have been much harder and much more ambiguous and much more filled with uncertainty and instability for society and governance and so on. But I'll just leave that as a thought. Ilya.
So that may well be a more interesting thought than the one that I was about to ask about. My name is Ilya Soman, George Mason Law School. Judge Jones just mentioned me a moment ago. In the spirit of Burkean shameless self-promotion that has arisen as a tradition, it seems, I actually have 2 books on sale and not just one outside. One called Democracy and Political Ignorance, which you can guess about political ignorance and its implications for constitutional design. Another co-authored with Randy and others about the Obamacare litigation. But I do actually have a question, and the question is this. For the originalists on the panel, and also I think other originalists, a crucial aspect of original meaning is how the constitutional text was actually produced. And that leads us to the question of what would be the status in this theory of the Reconstruction Amendments, which, at least according to a lot of evidence, were produced in ways that didn't actually fully satisfy demands of Article 5. For instance, the southern states were coerced in various ways. Now, segregationists in the 1950s argued this means we don't have to follow the 14th Amendment because it wasn't validly enacted. That's not my position, but I do think the issue poses a serious question for originalist theory, including especially for one like John's, which relies on supermajoritarianism as the validating factor of originalism, and why we should follow original meaning.
I think John's going to want to say something about that, but I just want to say that however it was ratified and however it came to be law, and whether that was according to the rules or not, the meaning of the text is what it is. So that secondary question doesn't affect the meaning of the text. That's the text that got in, even if it got in under ways in which it shouldn't have gotten in. So that's a very important way to distinguish meaning from other considerations that might also be relevant to whether something is binding or authoritative.
Well, I actually think that they are fully part of the Constitution, and it's, again, life is difficult in politics. You have to do the best you can. The southern states had succeeded. In some sense, you might ask about, well, what about all the statutes that were passed during the war? Maybe they didn't even have the proper quorum according to the Constitution. But I think the better way of understanding this is in that kind of difficult situation, I think that there was where states actually absented themselves, they were operating under plausible rules. Moreover, it seems to me that once one understands the exclusion of African Americans, it's the case that many of these states had very substantial African American populations, and if they had been able to vote, I think there may well have been a ratification. And I guess the final point about legality is I don't think there is a clear anti-coercion premise in Article 5. In other words, you can deal in Article 5 with giving benefits in return for votes. That's vote trading. That happens all the time in democracies, including constitutional democracies.
I'll just say something about the provocative thought that Judge Jones leaves us with. I don't know how many of us are big fans of the art of writing in the modern U.S. reports. I'm often not, for reasons that Judge Jones says. It's sometimes confusing, and it's sometimes a mess. If the question is about the determinacy of the law, it has the advantage over the Constitution sometimes of addressing the question at issue. But the more important point is the greatness of a document, here the Constitution, is not necessarily correlated with the tendency of its interpreters to understand it in the same way. Right? I know of perhaps only one document greater than the Constitution, and it is the document with the world record over time of being interpreted in different ways. And it is precisely the ability to interpret a document in different ways that sometimes maintains such a broad sense of it as great. Because even when we disagree with each other about substance, we can still locate ourselves in the document. being able to do that requires us to recognize that we do not all read it the same way.
Well, that doesn't explain why 5 justices can write something that us whose job is to interpret what they say cannot figure out what they say. I want to thank our panel. I think this has been a very enlightening and worthwhile discussion, providing a great deal of food for thought, and I thought we had a really first-rate conversation.
Thank you.